Good evening and welcome to 42BR Barristers. This is the third and final webinar which we're doing in our social housing series. If you'd like to have a look at the first two webinars, which I would recommend, Stefan and Andrew have done one entitled Unlawful Subletting, the Only or Principal Home Test. And secondly, Angela and Carolina have done another one, Foiling the Fraudsters, how to detect and collect evidence of tenancy fraud, slightly more evidentially based, as it says. Tonight, Matthew and I are going to be doing succession claim fraud. I'll talk a little bit more about that very briefly in opening at the end of this. But just to start with, I'd mention that we are anticipating that we'll have a little bit of time at the end, perhaps unusually. And if you'd like to send in some questions, they should go into the Q&A box, and we'll try to deal with as many of those as possible at the end of the session, time permitting, and/or we will follow them up by email. Alternatively, if you're watching a recording at your leisure, and after the children have gone to bed, and after the new American president has been elected, perhaps in the future sometime, you're perfectly well entitled to send in questions. We'll try and deal with them, and you can do that by sending those to events@42br.com. Lastly, I'd mention that an email containing this recording and the slides, as well as a feedback form, will be circulated to you in a few days' time. And the recording will also be available on our website and on our YouTube channel. So, just to start very briefly, what are Matthew and I going to be doing tonight? You'll see that the title of the webinar is Succession Claim Fraud. So we are going to focus on secure tenancies. We're going to focus on the Housing Act 1985 and the substantial area of work that there is relating to claims to succeed to what are obviously very valuable pieces of property, social housing stock. And the fact that, obviously, occasionally we come across what amounts to wholesale fraud in attempting to procure a succession. Now, we're not going to focus too much on fraud as such, or we will be discussing fraud. The way we're going to do this, we're going to look at 4 situations, and we're going to discuss the law around those 4 situations. And there is a theme which is and focuses on the fact that obviously in a case where the tenant has died, you're obviously dealing with an elderly, or usually dealing with an elderly tenant, and in many cases you're dealing with a tenant who at some point in time prior to death has required care. And as practitioners will know very well, that means that there are a number of different potential situations that arise out of the care that is being provided for the deceased tenant. And I think it's quite interesting and quite helpful to analyse the different ways in which the care can be provided, and just before the death of the deceased tenant, and the general circumstances in which then claims for succession can arise, and as we say, fraud can potentially be very tempting for those who have been associated with the deceased tenant. So I say we're going to take 4 scenarios. Matthew's going to start with 2 scenarios, and then I'm going to finish with 2 scenarios, and then hopefully we'll have 5 or 10 minutes at the end for some questions. So at that point, if you're happy, I will hand over to you, Matthew.
Brilliant. And so when we're looking at succession, really there's 3 areas that we're looking at. First of all, statutory. We're looking at secure tenancies in the Housing Act 1985, Section 86A, which I'll look at more detail in a minute. There's also contractual succession. So that's what do the terms of the tenancy agreement say, and how does that set out succession rights? In addition, there's discretionary tenancy, and usually a local authority will have a policy, and that requires 12 months residence or some amount of care being given. And so those are the three ways that succession can arise. Looking at the Housing Act 1985 and some of the key provisions, you've got Section 81, which sets out the tenant condition. And that's that a tenant is an individual and occupies the dwelling house as their only or principal home. That's one of the key tests and the language that arises again and again, as we'll discuss through the examples. It comes up again at Section 86A. So this is people who are qualified to succeed, and it's that a deceased tenant's spouse or civil partner succeeds if they occupied the property as their only or principal home at the time of the tenant's death. In addition to that, for secure tenancies before the 1st of April 2012, there was even greater succession rights, and they've been reduced as time has gone on because local authority housing stock is a scarce resource. So for secure tenancies before the 1st of April 2012, it's Section 87, which is repealed. And that's that a member of a tenant's family succeeds, one, if they occupy the property as their only or principal home at the time of the tenant's death. And secondly, that they resided with the tenant for the 12 months before the tenant's death. And so that's the language that we're dealing with that arises both in contractual succession as well as discretionary succession. The first scenario I'll be dealing with is a secure tenant who is in a care home when they die. And before then, the successor lived with the tenant until they moved into the care home. And so the legal questions that arise in this scenario are, is the successor residing with the tenant despite the fact that when they died, they were in a care home? And is the successor occupying the property as their only or principal home? And so going through that in a bit more detail, looking at some case law, we've got the case of Hedgedale Limited and Hards. And this case goes towards where a tenant has a temporary absence from the premises in question. So here you've got a grandson who lived with the mother and stepfather. In summer 1987, he moved to live with his grandmother. Shortly thereafter, the grandmother broke her arm, and so she moved in with the grandson's mother. At that point, the grandson stayed in her property, and it wasn't until Christmas 1987 that the grandmother moved back and lived with the grandson until her death. The question is, looking at that period, you've got a period where the grandson and the grandmother lived together. The grandmother, who's the secure tenant, then moves out, and then she moves back into the property. What the court held was that the grandson resided with the grandmother for that entire period, despite her temporary absence. And the reason why that was is because the grandson was physically in the property and he intended to be there when the grandmother returned. And so what the court is looking at with residing with is there's some examples of the wording that the courts have used over time. It's something more than living at. It's about making a household with the tenant. And so in that case with the grandmother and the grandson made a home with his grandmother. He wanted to stay there and he intended to stay there once the grandmother returned. A mere physical presence isn't enough, and it's been said that there needs to be an intention which can be characterized as making a home with a tenant. This line of cases is all to do with people who move in with their relatives when they're unwell and they may own other property. And so it's looking at the intention of that person once they're in the premises with the tenant. Are they trying to make a home with them, or are they simply there to provide care? We've also got the case of Dudley Metropolitan Borough Council and Mayley. In this case, there's a secure tenant who permanently moved into a care home. And so this is slightly different than the previous case in that it's a permanent move. They couldn't return home because they had dementia and they were staying in the care home. They couldn't assign the tenancy because they lacked mental capacity. And so the tenant's daughter who lived in the property could not succeed when her mother died, as the tenancy had lost its secure status. And what I mean by that is that the secure tenant, the mother in this example, was no longer occupying the home as a principal or only home. This case was appealed and went to the Court of Appeal, and the Court of Appeal determined that it was not a breach of the daughter's European Convention on Human Rights, and that the case was pleaded on the basis of discrimination, but the court went further and said even if it was indirect discrimination, it would be justified on the basis that housing stock is a scarce resource, and that it was a legitimate aim, limiting succession rights in this way. And so things to consider if a relative has moved to a care home: are there prospects of the tenant returning home? If so, that would suggest that the move is a temporary absence, and therefore it's likely that the successor is still residing with the secure tenant to meet that element of the test. If the move to the care home is permanent and the tenant will not be going back to the property, that would lean closer towards the successor not residing with the secure tenant. And there's obviously factors that can go either way, depending on the illness, what sort of care they're receiving, whether they can receive that care at home. And really, it's to say that this is two ends of the spectrum, but as general principles go, that's the way to view that situation. The second scenario is a secure tenant is being cared for by a relative elsewhere before their death. So this is at a property that isn't the premises to which succession is claimed. And the questions we're looking at again is the successor residing with the tenant, even though they're at a property elsewhere? And close to the tenant's death, has the successor moved into the premises and now occupying them as their only or principal home? It's the case of Waltham Forest, London Borough Council and Thomas. And in this one, a secure tenant, they lived with their brother for 2.5 years in property A. At that point, the brother and the secure tenant moved to property B, and 10 days later, the tenant died. And so taking the literal wording of having to reside with for 12 months, the local authority disputed succession on the grounds that the brother hadn't resided with the secure tenant in property B for 12 months. However, it was held, Section 87 does not require residence to have taken place in the property for which succession has been claimed. And what that means is that the important point is the 12 months residing with, and that can take place at any different premises, so long as at the date of the tenant's death, the successor who has resided with the tenant for those 12 months in any number of locations is in the premises to which succession is being claimed, and that's their only or principal home. And so that's what this slide summarizes. Those things to consider are: residing with doesn't necessarily mean the subject property of the secure tenancy agreement, and occupation with the secure tenant at other premises will suffice. The key thing to look at is the 12 months of residing with, wherever that may be, and the location at the date of the tenant's death. I don't know if you wanted to add anything to those two scenarios, or if I just hand over.
Yeah, well, I think probably it's worth looking at the four scenarios and seeing the way that they run together. The first scenario that Matthew is talking about, obviously, when somebody's gone to a care home, at the end, there's a real problem there for the hypothetical successor, because there's likely to be objective evidence that the tenant has gone to the care home, and there's a difficulty there to start with about this issue about residing with, and whether it's realistic that the tenant could ever come back to the property. And if the tenant is not realistically ever going to come back to the property, then in those circumstances it's going to be a tall order. I think it's going to be a tall order to satisfy the residence with test. in that particular scenario, probably the property has become vacant.
Yes.
And for that reason, unless there's any other competing person, the putative successor is going to probably be able to establish the only or principal home test at the date of death. And there, the issue really is it's really whether there is residence with. And I have to say, no, it's not going to be something that's going to be very. It's not going to come up very often that once somebody goes to a care home, it's realistic for them to go back. I mean, again, we're living in times where it's a big decision usually for elderly people to go to a care home. It tends to be a final decision, and there are usually good reasons for that, because the family and or the tenant themselves are unable to care for themselves. So it tends to be a last resort decision. And in that type of case, I think you're going to find that there's going to be as a landlord, if you're acting for the landlord, it's going to be quite straightforward finding some sort of evidence or implication that the tenant won't be going back, and very difficult on behalf of the successor to establish a real prospect of going back, which is the test. And the second scenario that Matthew is discussing really segues into the third scenario that I'm going to talk about now. So if I move on to scenario 3, and I'll just do a comparison between scenario 3 and scenario 2. Scenario 3 is where the secure tenant requires care which the successor is providing regularly at the property. And I've put in there, it could be a son, it could be a daughter, it could be some other relative. I put in daughter, just happens to be that I have a case which was a daughter, and that's not an uncommon situation. Why do these sorts of situations give rise to, and this situation, scenario 3 and scenario 2, why do they give rise to fraud claims? Obviously, local authority property can be significantly larger if it is a better part of the stock, and obviously, as a subsidised with a subsidised rent, economically, a secure tenancy is extremely attractive on the financial front. And this is not uncommon, if the tenant's family are aware of the implications of succession, and they have set themselves up carefully in the way they're going to approach the end of the tenant's life with a view to trying to make a successful claim for succession. I think the reality is that it's going to be, from a landlord's point of view, it's going to be very difficult if they've done things quite properly and they've organised their affairs accordingly in order to make sure that the succession occurs. I mean, obviously, there's an unpredictable quality to when the date of death is going to be, and obviously you've got to satisfy 12 months of residence with before that date, and that's not entirely predictable. But so in some circumstances, in some types of illness, in fact, it's a little bit more predictable. So that can be sent up. I suppose probably it's less common that's the case, and more commonly it only occurs to families of the tenant more towards the end, and once the end is in sight. And in those circumstances, of course, they'd be thinking about how their affairs might be arranged and see if they can sort things out in order to get a succession. But it's obviously very clear why social housing is attractive. And what we have in scenario 2 and scenario 3 is, and I'm going to describe this slightly pejoratively, but what we have is either the tenant who's very unwell and has gone to a care home, I beg your pardon, is very unwell and has been looked after somewhere else, in other words, not at the property, but at, say, a relative's home, or if the tenant is remaining on site, a relative, is probably going to be a relative, is coming in to care for them. Now, in both of them, there's quite a lot of similarity, I think, in practice between those two situations. And what you find is, what you find is in those two situations is that the members of the family will probably amongst themselves have decided, if it is a situation where there's a lot of there's some sort of planning and some sort of idea behind creating a claim for succession, what they will do is they will, and it's very often if it's a grandmother or a grandfather who's unwell, and it's the grandfather or grandmother has gone to live at their child's property, or the child has come in to look after the grandmother and the grandfather. It's not uncommon for the grandchild, when the property, it's anticipated the property will become available, that it's the grandchild who's going to move in and going to take over the property. And those two situations, they're not dissimilar. So it's probably more in the first case in scenario 2, because the tenant has gone out to the relative's home. It's probably quite a settled home, and the idea being is possibly a child of that family, a grandchild, effectively is being identified as a person who could succeed to the tenancy. Perhaps the scenario 3 that I'm about to talk about, that's perhaps slightly different. If the daughter, let's say the relative who's providing the care is coming in, that relative may consider actually that they want to move in. That's certainly a situation that arose in one of my cases. Alternatively, the relative who's providing the care may decide that they're perfectly happy, they've got some other home elsewhere, and nevertheless they have a grandchild who is being lined up to take a succession in relation to that property. So as in scenario 2, we have the two basic questions. Is the successor residing with the tenant? And is the successor occupying the property as their only or principal home? So I'm going to go over some of the same ground. No two lawyers take precisely the same view of anything, and I'm going to quote from, I think Matthew has already quoted from Freeman Islington, but I'm just going to give a slightly more extensive quote from Freeman Islington on the test residing with. I'll just read it out. It's up there in full on the screen. The words residing with are to be given their ordinary and popular meaning. There's a difference between residing at the deceased tenant's premises and residing with him. The words connote some degree of shared living as part of the deceased household, or some degree of factual community of family living and companionship. Whether someone is residing with the tenant is a question of fact and degree for the judge, with which an appellate court can only interfere if the judge misdirects himself in law or the decision was perverse. Let's not worry about the appellate qualities of this decision making. First point to note is this is a question of fact and degree, and as we all know, that means it's going to be the question is very fact sensitive. It will always turn on all of the facts of the case, and the facts of other cases provide limited guidance, usually in relation to how the judge will decide this case that's in front of you. So what I'm going to do is I'm going to ask you just look at the words in the second sentence, and this is really the test. What is residing with? There is, in the first sentence, it says it's different to residing at. Come back to that. But let's just look at those words. The words connote some degree of shared living as part of the deceased household. That's one way of looking at it. Or alternatively, some degree of factual community of family living and companionship. Now, I don't want to be too scathing about legal tests and the way that the law is set out, and indeed the common law and judicial made common law. Those words are quite general. They're not. There's a lot of room for meaning, quite a wide meaning in those words. And as far as I'm aware, there's very little authority which has boiled those words further down beyond the meaning that they bear on their face. So there seem to be two alternative tests there. You're residing with someone if there is some degree of shared living as part of that person's household. Some degree, not 50%, not 75%, just some degree of shared living as part of a household. I'll come back to this. An alternative way of saying that is some degree of factual community of family living and companionship. And I'll be honest, I'm not absolutely certain entirely what that phrase factual community means. Factual community of family living and companionship is very broad and not very precise. So we're going to consider just how easy is that going to be for our carer, in scenario 3, who has come into the property to look after the relative. How easy is this test going to be to satisfy? So I'll come back to that. But before I talk about residing with a little bit more, I just want to go almost a little bit more fundamental, because the first sentence of this quote deals with the notion of residing at. Now, what does residing at mean? And I think really fundamentally it means residence, occupation as a residence. And that's a test that is a very fundamental test that sits across the entirety of protected tenancy legislation, short-term tenancy, statutory protection. And it's worth just reminding ourselves what the word residence means. It's not entirely clear either. And immediately I take you to a test in Middleton Ball which says whether or not somebody is a resident, is in residence, is a question of fact. You might as well have said question of fact and degree there. So it's a question to be decided as a matter of common sense almost. A person in hospital will not be treated as out of residence, for residence does not necessarily imply immediate presence. Matthew's talked about that scenario number 1. Court will look at circumstances of an absence to determine whether or not a claimant should, in a popular sense, be considered as residing in the premises in question. That's bringing absence into the framework, as I'll come back to that. One approach may be to ask whether the premises in question would be what the claimant would give as his address, where he keeps his possessions, his place of past and future habitation, whose absence denotes no intention to move elsewhere. So those are the sort of practical questions you ask in these cases. What address has been given to the doctor, to the school for the children, to the employer, and to other bodies? Where is the person's clothes, or where their bed, where their possessions are? And it very, very commonly comes up, where does the post get sent to? Quite interesting. The word home doesn't crop up in that. Nowhere there. I know Matthew mentioned an alternative test, which talks about, in the context of residing with, which talked about home. But home is not a word that's commonly used in this test. They try not to focus on that. And perhaps a residence might just fall short of a home occasionally, although it is a residence. Just continuing on there, the test of occupation as a residence can also be illustrated, and this is quite an important, I think, aspect of it. It can also be illustrated by addressing the question where there is a conflicting and apparently inconclusive evidence as to a person's ceasing to reside somewhere. Essentially what that's saying is, and putting it, that's a rather long-winded way of putting it. When we're thinking about residence, it's actually quite, we can get to the heart of what it is when a person has moved out, and we're asking the question, after they've moved out, does this remain a person's residence? And the courts are very clear on this. Here, the starting point is that the onus is on the landlord to show non-occupation amounting to non-residence. And if the landlord does that, it's then down to the tenant to prove residence. What does the tenant have to show? The tenant has to show, this is the bottom section of this quote, a very important case, Brown and Brash, still being quoted today from 1948. The tenant must show the necessary intention to return, plus visible signs of that intention to return. There's the mental element, almost like a mens rea and an actus res, a mental side and a physical quality. So coming back to residing with, assuming that a person, just to tie those two things together, does a person have to actually be residing somewhere to be able to reside with? That's really the question that I'm asking. I think the answer is probably you do need to be residing somewhere. I don't think there's any explicit legal test that says that, but I think common sense requires that's probably correct. So having said that, the point that's being made in the case is it's not enough to be living there. You've got to actually be living with the person. So what is the threshold here? What do you have to show to live with someone? Do you have to have shared bills, or do you have to share meals, or share time, leisure time together? And there's no, as I say, there's no hard and fast answer. So in our carer, our relative who's coming back in scenario 3, and they are providing care for the tenant, they might be there for a large part of the day. They might be helping them get up in the morning, cooking them meals during the day, and in between they might go out shopping. They might actually be splitting the bills of the meals. That's something they might be doing. And in between meals, there might be leisure time. They might be watching television together. Is that residence with the person? Is that actually sharing sufficient? If we go back 2 pages, is that sharing sufficient amount of living with another person to be described as being part of their household? One can see how easily that might. One can see that quite readily that might be satisfied by another family member who's going back to provide some care. There's sort of a continuation of the old family life, spending time together. I think in truth, in practice, it's probably quite a low threshold for a family member to satisfy, as long as it's genuinely satisfied. So you might compare that, for example, with a professional carer, and just comparing a professional carer probably doesn't spend their own money when looking after someone. They don't probably watch the TV at the same time. They don't take meals together. They probably prepare the meal, then sit separately. That's not uncommon. So in our second scenario, we have a relative who's come back to look after the deceased, the tenant. Are they residing with the tenant? And the answer is that it may actually be quite easy for them to satisfy that. The next question that they have to satisfy, the next test requirement that they have to satisfy, is they have to satisfy the only or principal home requirement. I've just mentioned here, and I'll refer to the test for only or principal home again in another, in fact, the dominant test. But I've just mentioned here the test, the light that was shed on the test by a Court of Appeal case called Sumagova and McMahon. There's a very nice piece of dicta which says that in deciding whether a premises is a person's only or principal home, the fact that a person sleeps there is of the utmost importance. I think it's if it's not the utmost importance, it's certainly a highly relevant factor. If our carer is actually occasionally staying overnight, you can see how it would be actually quite easy for the carer's case to become quite strong. If the carer is doing something like that, staying out overnight, not only will they be able to show that they've spent significant time during the day with the tenant, but sleeping there overnight will add to the strength of their case for succession. And I think at that point in time, the question is, well, how often are they then spending time at the property and sleeping there? Because if they're sleeping there most nights, if they are effectively a live-in carer, then I think actually there's going to be no question they've got to have a strong case, and there's unlikely to be any need to resort to fraud. The more problematic situation comes is where the relative lives quite close by and they have another property. Now that then becomes an issue, because if they have another property, they may well have another family life in this other property, and they may not want to give that up. It may well have sufficient momentum that it's very difficult for them to just up sticks and move the whole of the family into the tenant's property. So if you are being very cynical, I'm just going to be cynical for a moment. If the relative, who's the putative successor, would like to inherit the property in which the tenant is living at the moment, they've got to think about that. They know that they effectively spend so much time, or enough time, to qualify as a residing with, lots of time spent in the property. They've then got to focus on what are they going to do in relation to the only or principal home test. Now here, Obviously, one way of doing it would be to terminate, if they have a tenancy elsewhere, to terminate the tenancy. That might work. Or possibly to, if they don't want to terminate the tenancy, to show nevertheless that they've moved in wholesale and that they are living full-time in the tenant's property. But there is often a real tension here because, as I said, this carer probably has a life, may have children, may have a partner living in the other property, and that is probably going to create a situation where there is a degree of shuttling going on between the two properties. Substantial care is being provided, and then going back for periods of time, particularly at night, to see the family and see the partner. And this really is where you then start asking the question about, well, is it the person, even if the tenant's property is seen as a home, is it their main home? And that really is likely to be a real problem for them there. And of course, the key date is, the date of the death of the deceased tenant. And the question will be, well, had they by that date genuinely moved into the tenant's home as an only or principal home? And that's going to be very difficult in a lot of situations. Nevertheless, you see the cases brought forward, but it will be very difficult for them to do. And there you're going to be examining the question about only a principal home very carefully. Perhaps almost it's not as straightforward as situation 2, because as I've said, in situation 2, in that situation, the carer will usually remain at the other property. That's the reason why the tenant has moved out, to be cared at the other property. There's room to move. There's room to move the tenant in, to look after the tenant. The idea of the tenant moving out connotes that the other property is a place that the carer wants to remain, and that is not looking to inherit. And in that situation, as I said, in scenario 2, it's more likely that the thought will be maybe a child can move in, an adult, or a teenage child, or a child that's more a young adult child will move in, and that tends to be, you tend to see that situation more often. So back to scenario 3. You have an adult relative who's providing a lot of care, wants to try and make a claim for the tenancy because in the circumstances of that case, they prefer it to the place they're at. But they have this difficulty of their ongoing life in their other property. And it may well be that they're going to fail if on the basis that they haven't moved. It's not yet their main home. And that may be a classic situation, of course, in which you're really faced with quite a strong discretionary tenancy claim. Although whether it's right to say there's ever a strong discretionary tenancy claim is doubtful. There's certainly a compelling discretionary tenancy claim, as is well known, as long as a local authority goes through all of the proper reasoning and takes into account all the relevant factors and doesn't take into account any irrelevant factors, and weighs the matter carefully in accordance with the principles and the factors set out in any policy that they have. It's very, very difficult to challenge a well-made decision that refuses to grant discretionary tenancy. That's not to say that they don't get granted, they do. And as I say, scenario 3 can give rise to compelling cases. So moving on, just lastly, I move to scenario 4. Now, scenario 4 is really, I know we said fraud at the start of this, and we've talked a lot about care, and fraud can arise out of both scenario 1, 2, and 3. But scenario 4 is really the classic one. And that is where the secure tenants, as I'm just reading from the sheet here, the secure tenant requires some care. And there is limited evidence that the successor, and it's often seen, it's a grandchild, and this has been, experience shows that this comes up not infrequently. There's limited evidence that the successor has been present at the property and or provided some care. And this is really a case where you're going to have to look hard at the two requirements, the residing with requirement and the only or principal home requirement. In a way, the only or principal home requirement may well be easier for them to satisfy, although because it's just satisfied on a particular date, whereas the residing with requirement does carry this quite onerous 12-month period that needs to be met. But the reality is often that actually the two things stand or fall together, because if the person is trying to is actually be living elsewhere, it's not a strong claim on either footing. Cases where the grandchild clearly does go in at the end and is in there for the last week or the last few weeks, and that cannot go, that can go back to and relate, that can actually overlap with the scenario one where the tenant has gone into a care home for a few weeks, or is just simply in hospital and unwell for a few weeks. That kind of situation can throw up a situation where clearly the grandchild is intending to live there, and it's really about the 12-month period that's the critical matter in that case. So, just turning to some thoughts on the residing with and the O'Neill principle home test here. Starting with residing with, it's extraordinary how there are obviously a large number of tenants in social stock who are receiving care, both from social services, also obviously supplemented by family members, or sometimes solely by family members. What's extraordinary is how there are a large number of them are provided with care by social services, and yet the records never seem to be very easy to get a hold of. When you do get a hold of a care record in a case, an assessment, you might get one, or you might get a couple. You don't seem to get a continuous series of them, although they're supposed to be assessments are supposed to be regularly done. And this obviously is very good evidence that you can use, and invariably will provide quite compelling evidence about what has actually been going on. If we're looking at this as a fraud case, what will be said is that the grandchild or another relative is in there. This is the type family have targeted. This is very useful for as a future home for this particular grandchild. And what's being said is that the grandchild, and to provide a logic for the judge, grandchild's in there providing some care, and it may not be bathing and clothing and that type of care, but it might be shopping, and invariably it's quite low-level care, characterized as care, shopping, cooking, taking someone to appointments. Sometimes, no doubt, that actually occurs, but sometimes it sounds rather unconvincing when you see that the claims being made. And of course, care records, if you do have them, are invaluable evidence to show what is actually taking place. So that's useful to help us as a tool for assessing whether someone has actually been in there genuinely, and if they aren't providing care, and there's no evidence that they in these records, that their name's not mentioned in these records, their claim then to be residing with the deceased tenant starts to weaken substantially. The financial position is obviously always going to be relevant. How much shared living could the tenant afford? How much shared living has there actually been? Often you'll see council tax and housing benefits records wheeled out as evidence that in fact there was nobody in there living with or residing with the deceased tenant. I say it's habitually rolled out. You see this almost in every case under the 1985 Act, these sorts of issues. But it has to be said that sometimes this evidence can be very weak. Experience shows that people sometimes do live with someone else, even though they're not declared on the benefits, and it's invariably not a knockout blow in most cases. Although judges may use it to assist making a decision one way if that's the way the judge is going. And then, of course, you'll be looking at the wider picture of the successor's life, looking at the expenditure in their bank account, and if you can, identify where this person has been spending most of their time. Again, it's not easy to get a hold of the bank accounts, and it's as a matter of litigation, you can't say it's a good idea ever to tell the other side in litigation to look at their bank accounts and identify where they spent most money in the cash points and supermarkets where they're shopping, and that's not a litigator's instinct to do that. And you don't often see this in these cases. You don't often see putative successors coming forward with their bank accounts explaining that they've been shopping in at the local corner store very, very frequently, and therefore that indicates strongly that they were residing with the tenant. You just really don't see that very often. Although it would be an obvious method of establishing that, or going some way to establishing that. So you're faced with this claim of somebody being in there and residing with, and I'll refer you back to Angela and Carolina's webinar on Evans as well for more thoughts about that particular matter. You're also going to have to look at the question of the only or principal home issue as well. What I've done there on the next slide is I've set out the leading judgment. This is really more for a reference point for everyone. I'm sure you're familiar with Islington and Boyle. Funnily enough, this expression of fundamental principle, which is a leading principle, and it's principle relating to what the only or principal home test means and how you've got to approach it, is actually very similar to the way in which Brown and Brash approach the question of residence at, this idea of the presumption that you're living there, and if you're shown to be away, well, then the tenant then has the onus of proving it, and it has to be proved by objective facts, and you have to establish an enduring intention. And this brings me to my sort of some final thoughts about only or principal home in relation to scenario 4. What sort of period of time do you assess a person's enduring intention in relation to whether a place is their main home or not? Obviously, the scenario we're talking about in scenario 4, the family have got together and said, well, we'll pop Joe, or we'll pop Amelia into the property, and they've been going round there and seeing Grandpa for on and off for a period of time. We'll say they were in there, and we will say that that's the place has been their main home. How do you go about assessing that? What sort of period of time would you look at? I think the generally accepted rule of thumb is to look at where that person has had a home for about a year. That's not an invariable rule, but you might go back a year and ask, well, if they say that was their main home on the date of the death, but where were they before that? And you would maybe assess that to decide whether there is good objective evidence of an enduring intention that a person had decided to was living at this particular property. And if the successor is not undermined when considering the residing with test, and you're really down to this, it's a separate test. If you're down to this, that's still a separate hurdle that they've got to get over. And a related question here is whether a person can change their intention regarding their home. So somebody who has been going round and satisfies the lighter requirement of residing with, but can establish that for 12 months, even if they have been living predominantly at some other property, can they decide that they're going to inherit a grandparent's property? And can they make that decision fairly close to the date of the tenant's death? And I think the answer is, in principle, there's nothing to say that can't happen. But as a general rule, the courts do like to see some settled intention, and it will obviously be weighed carefully against what the residing with requirement and all the evidence about what's been going on in the year before the death. So we've reached 10 minutes ago. I'm just say one final word about this area of litigation, and then we'll take some questions. I just want to mention the potential unpredictability of litigation. I had a case as a session case, and I hesitate to call it a success, something that's suitable for discussion in this particular webinar. But this particular case concerned, and I'm changing the details a bit, concerned a schoolboy who lived out of London with his mother, and who, for reasons of getting into a better school, decided to move back into London, into a London borough, and he proposed to live in that London borough with the view to getting into that better school. And in that borough lived his father and his grandfather. Now, the question was whether he had moved back in the facts of this case with his father, because his father died, and because that's why it's relevant. His father died, and the question was whether the son was able to. He was only 17 at the time he moved back to London. It was a few years later that the father died. The question was whether he could properly had a right to inherit as a statutory succession of the father's secure tenancy. Well, the father was a very heavy drug addict. He died from drug addiction, sadly, and about 50 yards away, up the road from where the father lived, his grandfather lived, with whom this particular schoolboy had an extremely good relationship. The grandfather had a house which was large enough with empty bedrooms, and the schoolboy could easily have lived in there. Nevertheless, the claim was made that the schoolboy, the ages of about 17 and 18, had actually lived with his father in a very small flat, which was only one bedroom, and did his exams in circumstances where the father it was accepted, having other drug addicts coming back and taking drugs, and that he did indeed. That's where he lived. Now, there are other reasons in the case. I won't go into the evidence too much more. Why it was obvious that the schoolboy was living with a grandfather. That's absolutely obvious. And nevertheless, on the facts of that case, the judge decided on all the merits and all the facts that, in fact, he had been living with his father. And that was an extremely unpredictable result in a succession case. And experience shows that they do from time to time happen, that those are judges. And that's why, obviously, all of the evidence has to be sifted extremely carefully. But at the end of the day, you have to be aware of the litigation risk that exists in these types of cases. So on that note, I'm going to now ask Matthew to field a question, which I see Sophie has sent us.
Yes, I've seen one, and it's that a resident moved into a care home and passed away. However, they themselves were a successor, and so that's a bar to succession. And therefore now her son is requesting succession, but a discretionary tenancy. And so looking at that, it comes back to that, well, how permanent was the move into the care home? If it was more permanent and there's evidence supporting that, then that would suggest that the son was not residing with his mother in this example. And therefore looking at discretionary tenancy policy most likely wouldn't meet that, and therefore a discretionary tenancy shouldn't be offered. But it comes back to what are the terms of the policy, and assessing all of the evidence and arriving at the decision, having weighed all of the relevant factors and not taking account of irrelevant factors. But in that example, if it was a permanent move to a care home, that's closer to suggesting that the son wasn't residing with the care home resident. There's another question as well, which says that can a council's tenancy conditions grant greater rights over and above the legislation? Yes, it's looking at the terms of the tenancy. And so if you have really old tenancy agreements, quite often they will talk about extended family living with the tenants and offering them a contractual right of succession. Whereas as time has progressed, succession rights have decreased. And so yes, if you're dealing with an older tenancy, often they will talk about family members, as well as what remains in the statute being spouse and civil partners.
Yes, just thinking about the mechanics of that a long time ago. I'm just thinking about what the mechanics of that would be. I think there's nothing in principle wrong with granting greater rights. That's a matter of contract. The question would be, well, who has the right to enforce the contract in the and does the putative successor who wants to inherit, do they have the right to enforce the contractual right? So you've got some things. I don't know very much on the Third Party Contracts Act. I don't know if you do, Matthew.
No.
But you've got the Third Party Contracts Act to think about. Another possibility would be for the personal representatives possibly to take a claim against the local authority, that they would have contractual right, arguably they have contractual right to force the local authority to they can enforce fall on behalf of the deceased tenant, enforce the authority to comply with the contract. That's not to say that if there's a clear contractual right, the local authority or wouldn't comply with that, which as I'm sure they would, being sensible about it. Right, I'm just going to read out. We've got another one here. I or Matthew may take it. Can you refuse a succession to a husband seeking to succeed, given that he married the deceased tenant a day before her death and never lived with her prior to her death at the tenanted property? Right. Right. Well, I think that the husband, if this is a I think the test is the same, whether it's pre or post April 2012.
Yeah,
and I think it's simply whether they're living. There's no residence requirement, so it's just simply whether they occupy the property as their only or principal home.
Yes.
So it's really, even though they're married the day before, I mean, and they never lived prior to the date of death. Well, I think they may have a good case, even though it's on the basis of the day. That goes back to what I was saying about whether you can satisfy the only or principal home test by a clear, objectively verifiable, enduring change of mind on a given day. And I think probably that must be right, because where your only or principal home is not always dictated by where you've been in the previous 12 months. I mean, you may when you buy a new house, if you clearly go to the new house on that day, and that becomes your new home, and possibly in the period when you've identified the house and entered into a contract, there might be a twilight period where you're hoping that it'll be your main home. Probably might even be regarded your main home as well. Maybe not. But the point is that on the day of completion, it's your main home. And I think there's maybe an analogy there with getting married to someone and moving to a new property. So let's have a look at do you want to take that one on the top there? What if the care records are within 12 months of the death? What if the care records within 12 months of death state the deceased was living alone and the council tax records show a single person discount? Yes, both commonly seen. But the deceased's lasting power of attorney for health and welfare states and supports the successor claiming to have been living there for 12 months to take care of the deceased prior to death. Well, that's interesting. That's interesting because it looks there as well. I think what you may have to do there, I wouldn't give a definitive answer on that. I'll hand over to Matthew to have his thoughts in a second. I think probably you would imagine that the care records might give an insight into what's going on. You might also imagine the council tax records do. And it's just possible, if there's a lasting power of attorney, that the tenant has lost capacity at some point in time. And if the power of attorney is very much being dictated by what the putative successor is saying, that may need to be examined more carefully as to whether it's really true. So that's all I would say without saying one thing or the other. Do you have any thoughts about that one?
Yeah, I think it just shows that it's this jigsaw, isn't it? And you're trying to find the different pieces of the evidence, but you would be looking at the intention of the person who is the lasting power of attorney. Have they only come into the picture because of capacity, or have they been there all along?
Yeah, I think the question, though, without actually saying, is possibly implying that maybe the person who's got the lasting power of attorney has exercised exercise some sort of pressure or control and possibly stating things for financial advantage that might be inappropriate. I think that needs to be examined very carefully. I see also there are credit check links showing the successor at another property, at other properties, including the subject property. Again, that needs to be examined very carefully, I think. So that we've done a few of those. Let's see if there's anything else. What happens to a tenancy agreement created before 1985? Can a person who is alleged to have cuckooed force their way to live with a vulnerable tenant, if proven, be allowed to succeed? Well, I don't want to answer the question about statutory schemes prior to 1985, because that is part of the dim memory of this particular scheme that requires a certain to be refreshed before we answer questions live on that point. But what do you think, Matthew, about what are your thoughts about can a person who's alleged to have cuckooed force their way be proven to be allowed to? Any thoughts on that? So what you're saying is it's somebody who's essentially this has got a similarity with the last question. Supposing somebody's taking advantage of the situation, getting themselves into the property with a very vulnerable person, would they be allowed to succeed?
Again, it would take looking at the evidence and whether all of that arose once it was known that the secure tenant was unwell and that they were approaching their death, and what sort of control that person was exercising. Was it just of their finances? Were they also taking them to appointments? All of those sort of questions. And if it's just a very limited, short amount of time and seems to be mainly financial benefits, that would raise those alarm bells that the tests aren't met, and therefore a succession should not take place. It's a close factual look at what is actually happening in those circumstances.
Yes, I agree. That requires a lot of care and attention, that one. I think the only principal home test, not the one there maybe that needs to be looked at. I think it's the residing with test there. Is somebody who forces their way into somebody's life involved? Is there a degree of shared living as part of that person's household if there is force involved? Whereas if is there a degree of factual community of family living and companionship if force is involved? I think we might push on. That's the door. I think we'd suggest you push on that one. And the case you spoke of with the drug addict father was my case. I'm blown away by the outcome. I often wonder if we should have appealed. Well, that's an interesting one, but we obviously don't talk about the facts of any case. And as I say, the facts were made up in that case, so it shouldn't be identifiable. So I think to that person, I just say unpredictable, potentially unpredictable forum. The court is not obviously usually. Often the result is predictable, but these cases happen from time to time. Has anybody got anything else? If not, I think we'll wind the session up.
Yeah, so thank you very much for attending. Any unanswered questions will be followed up by email. And if you are watching the recording and have a question, please do email them through to events@42br.com. The recording will be available shortly on our YouTube channel, and we'd be grateful for any feedback. And as we said at the start, all webinars in this social housing series and beyond across Chambers practice areas are available both on our website and on our YouTube channel. So thank you very much for joining.
Good night.